So in this video, I'm going to talk briefly about the two main areas of the law that patent examiners use to reject patent claims. Now, when you first file a patent application, and for this video, I'm going to limit discussion to United States patent applications. So patent applications filed in the United States Patent and Trademark Office, the USPTO. So when you initially file a patent application, it's inevitable, almost guaranteed, that the first response, the first communication you'll get from the USPTO, which is called an office action, will be a rejection of your claims, and most likely, more likely than not, it's going to be a rejection of all of your claims. Now, that doesn't happen in all cases. There are some rare cases where some of the claims may be found allowable initially, but usually they're going to be rejected. The patent examiner will usually use one of two or a combination of two legal grounds to reject your patent claims. The first one is 35 U.S.C. Section 102, which is novelty. The second one is 35 U.S.C. Section 103, which is obviousness. So your claims, if they're not new, if there's prior art, what's called prior art that exists, that shows each element of your claim, then your claim is going to be rejected under Section 102 as being not novel, not new. And then obviousness is usually based on a combination of references. So let's first talk about novelty. What makes patent claims new or not new? Patent claims consist of what are called limitations. So one example claim, if I make a generic claim for an apparatus called a widget, a generic term for an apparatus, some type of imaginary thing. The widget can consist of a widget comprising limitation A, limitation B, and limitation C. We can also refer to those limitations as features. And sometimes in communication with the patent office, I'll refer to those limitations as features, but the proper legalistic patent attorney language for elements of a claim or for sections of a claim are limitations. So these limitations, A, B, and C, any one of A, B, and C isn't found in what's called the prior art, then the claim would be novel. Now, what is prior art? Prior art means either a patent, a printed publication, some type of a technical paper that was published before the date that you filed your patent application. So if the examiner is able to locate a patent that describes those features, those limitations that are part of your claim, then the examiner can use that as prior art, provided that the date is before the date that you filed your patent application. In the case of a novelty rejection, a 102 rejection, Section 102 patent law, the examiner has to show that all of the limitations are present. So if you have limitation A, B, and C, the examiner has to show that in the reference that they're citing. So let's say that they're citing a patent. The examiner would have to point to the sections of that patent specification that describes the limitations A, B, and C, and then could reject your claim as being non-novel based on that reference.